Okay, welcome everyone, and thank you for joining us, and welcome to our online participants as well. Before I introduce the panel, I just wanted to start by acknowledging the Yagara and Turrbal people as traditional owners and acknowledge their custodianship of the lands on which we meet today. And on behalf of UQ and the law school, I pay our respects to their ancestors and their descendants who continue cultural and spiritual connections to country. We recognise their valuable contributions to Australian and global society. On my own behalf, I want to acknowledge that sovereignty was never ceded and that many members of the Yagara and Turrbal people are engaged in an ongoing struggle for practical justice. Because of the subject matter of today's discussion, I also want to acknowledge the individual victims of the Robodebt scheme, some of whom are no longer with us due to sad circumstances discussed in the report, and many of whom are still experiencing what the Commissioner in the report, which we have here today, thanks to Paul, called the varied, extensive, devastating and continuing ill effects of the scheme. So I thought it would be improper to proceed without acknowledging those individual victims. So we have a all-star panel today to discuss the report, and without any further ado, I'll introduce them. We have Professor Paul Henman, who's a professor of digital sociology and social policy at the University of Queensland. He's also a chief investigator of the ARC Centre of Excellence for Automated Decision-Making in Society. For almost 30 years, Paul's research has investigated the use of digital and information technologies by governments in policymaking and service delivery, and the implications for citizenship and the operation of power. His research deploys both traditional and innovative digital social research methods, and his publications include Governing Electronically and Performing the State, and he's written authoritatively on the policy and legal implications of AI for the Oxford Handbook on Administrative Justice. And personally, from my own experience, if you're looking to start with Paul's work, that handbook article would be an excellent place to start, especially if you've got a legal background. It's really interesting. We have Associate Professor Yifui Ng. Yifui is an Associate Professor in Law and Deputy Director of the Australian Centre for Justice Innovation at Monash. Her research centres on the intersection between public law and politics, focusing on enhancing executive accountability, and Yifui is the author of The Rise of Political Advisors in the Westminster System and Ministerial Advisors in Australia. And one of her books, the most recent of which was a finalist for the Holt Prize. We have finally Emeritus Professor Terry Carney. Terry is Emeritus Professor of Law at the Law School, University of Sydney. For nearly 40 years, he was a part-time member of the AAT and its predecessor dealing with Social Security appeals. In early 2017, he handed down the first of 5 decisions finding Robodebt to be unlawful. And following non-renewal of his AAT post, he published academic articles exposing the illegality from early 2018. He has written widely on the role of AI and algorithms in welfare and is an associate investigator with the ARC Centre of Excellence on ADM and Society. And Terry's decisions are also featured in the Robodebt report. So I thought I'd start with a general overview question, and Terry kindly offered to help start us off. What was the Robodebt scheme, and in what ways did it differ from previous attempts to raise and recover debts for Social Security overpayments?
Putting it very simply, it was an extremely basic change to a data match between the tax office and its 6 to 12 months worth of employer reports of what people were earning on the one hand, and the fortnight by fortnight declaration by Social Security recipients of their earnings as the basis for determining from fortnight to fortnight their rate calculation. And the change was that in the past, those matches, an average calculated from the 6 months or whatever, if it didn't appear to fit the reported earnings, would be a basis for a human public servant, that is to say, looking at the file to see whether there were things obvious on the file that would explain that there was nothing problematic about the mismatch. And if it still appeared to be questionable as to whether the person had been correctly reporting their income and therefore paid the correct amount, to use statutory powers to require the employer or a bank to supply the fortnight by fortnight PAYE information. That led in the past to 7% of those mismatches being raised as a debt by a human decision maker. What Robodebt did was take the human being out of the process altogether. So 100% of all mismatches were raised as a debt. The onus was in the letter communicating that debt was put upon the alleged debtor to rebut the presumption that you owed this money. And the only way in which you could rectify the situation was to upload on an online system the documents, the PAYE or other documents that you might have kept from 6 or 7 or 8 years beforehand. And yeah, that shifted from the 7 to 100%, and just essentially responsibilized is the term that can be used, put all the responsibility for everything on the citizen. A citizen who, like most of us, would not have kept records of their often very episodic employment as a student or as an unemployed person. In the 5 cases that I heard, there were double-digit employers, so there were often multiple employers. I don't know whether Paul wants to add. I think that's the essence as I see it.
Yeah. Well, Paul, when we were speaking about this earlier, raised, so I guess it was sort of, I don't know if Paul, you can address both of these questions, but one question I had, I think Terry's already addressed a little bit, is to what extent was AI a feature of the Robodebt scheme? So it's often discussed in that context of automated decision-making. And as Terry just said, they took the human out of it. So I guess that's the first question I'd ask.
In answer to your question about AI, well, it depends what you mean by AI, but I think it's very easy to say absolutely nothing was involved in this process. AI will typically often be used to mean machine learning, but even if you expand that, it's definitely nothing. The commissioner refers to it as an expert system. I wouldn't call it an expert system. It was very much a rules-based system, very basic, and as Terry said, things that were in track for many years. In fact, data matching has been in place since the 1980s. And so this idea of income averaging being used to identify possible disparities is being used, but with a lot of human omen. The reality is that anyone who's had any touch with the Social Security law would know immediately, and that should be everyone that was working in the Department of Social Services and everyone who worked in Services Australia would know that you just can't simply annualise, get annual income and then fortnight, make it into fortnight. So Terry is completely right. The other thing about the automation is that they send out letters to people, and often people have moved on in addresses. If they didn't respond in a certain time, then the Services Australia took that as a nil response and raised the debt immediately. There are a number of other things that occurred, and so the debt matching problem also identified double up income. So if I said the University of Queensland in my return, and UQ's returns to the tax office said just UQ, that was seen as 2 different employers. So I got double the income. So there's some really basic things, and in fact, it was acknowledged at the Robodebt Royal Commission that they knew that there was a whole significant amount of problems, and they chose to do it anyway. And the idea is that they were seen by inducing people to provide information to comply. And the last thing I think what I need worth to point out is that there was a policy change to apply the debt surcharge to every customer with that had a debt raised. Previously, the debt surcharge was only to be applied for non-compliant or difficult customers to try to encourage them to pay a debt. This was done automatically. And also clients who had their were indicated as vulnerable were also had debts raised with them automatically at one stage. That then they reduced that, but all of the checks and balances that were in place were completely ignored.
Right. And so a related question that I wanted to ask you in particular, Paul, was we've spoken about the technology or lack of it used in the process, but what kind of techniques of public policy techniques were used to implement it? What was unique about it? Seemed to be that there was some sort of gamesmanship or gaming of the policy system.
Well, I guess in terms of the Royal Commission, one of the things that was found, and having been a public service servant myself for 3 years, where I was told to ask too many career limiting questions, and I think Graham will probably indicate that I asked the career limiting questions in the academic board as well, where was I going with that?
Gamesmanship
is that the senior public service probably knew what they were doing. There's a whole practice within the senior public service of operating in a way to create plausible deniability. So briefing ministers verbally, things like that, not recording certain things, and that could come out. So Scott Morrison, as the relevant minister, can say, I wasn't told about this because there was verbal briefing, and they could say, and he could just pull that back. So there's all of these practices that occur in the public service that enable that. That said, I think in terms of the enabling this practice, there wasn't really any policy changes. There didn't need to be any policy. It just went on without it. And I think it's probably worthwhile referring back to Terry, but there were a whole lot of legal processes that were used as a result. For example, the normal decisions made by Department of Social Services Australia would have a process of appeal, would have allow people to actually ring up or who to contact, particularly on debt matters. That was completely removed. People could not ring up, and they were, even when they did ring up, they were told they weren't able to be helped. And so the human factor was completely taken out of that whole process. And they were even told they weren't allowed to appeal. Now, I don't know how they ended up at the AAT, but that when Terry made and others overturned the precedent, the government would normally appeal that if they thought the policy was correct. They chose not to. And in doing so, that meant that the second level AAT decisions that are made public were not made public. And so that was one of the very many ways in which they played legal games. The other legal games they played was when it went to the federal court on 2 separate occasions. They zeroed the debt and said, well, we don't have a case to answer anymore. Or can you just dismiss the case, Judge? So I don't know whether there's other comments. Terry, did you want to comment on any other legal things? And I think it's important that one of the principles of law of government is as a model litigant, and it certainly didn't behave as a model litigant.
Yeah, there are multiple. I mean, there's 1,000 pages sitting there, and on most pages you find the gaming. There was gaming at the very outset, as Peter Whiteford has pointed out in his recent publications. Only 6% of people on social security have a stable income, and everybody knew that. I mean, it was the government's own data that showed that people have variable incomes. Well, the premise of the system was that it was reasonable to apply an average over 6 months or 12 months. There was gaming in the way the cabinet process, the new policy proposals went forward. There's a lot of technical things that were deficient and gamed there, but as Paul has indicated, most of them were just taking to the nth degree practices that have been emerging in state and federal governments over the decades of just having post-it notes so that the post-it note was no longer on the document, or having no documentation at all. The Royal Commissioner was astounded at the fact that big decisions had no paper trail. And as Paul mentioned, I mean, he said, how did these cases get to the AAT? Well, only 5 out of every 10,000 Robodebts did get to the AAT. 5 out of every 10,000. We know that for certain as a mathematical calculation. What happened to all the others? Well, most of them were headed off within Centrelink by the process. The early letters applying nudge theory, Cass Sunstein's got something to be blamed for, deliberately left off phone numbers or any other contact point in order to force people to use the online system. When people did get to lodge some kind of protest, for the lawyers in the room, that the bureaucrats' instructions and culture was to not treat it, not bring it to fruition as a decision. It was only a step along the way. And as the Bond case in the High Court, and it's the real Alan Bond that gave that ruling, it has to be a completed process of decision-making before it can be reviewed in the AAT. And you can't get to the AAT unless it has had a statutory authorised review officer review of the decision. And you find chapter and verse in the report of the evidence committed to writing of those policies, saying, it's a complaint, it's a concern, it's a need for assistance in using the online techo system. It's everything but a decision.
I might add to that. So I'm also an escaped public servant, sayonara public service. But what I can say is that the Robodebt Royal Commission has exposed a very fundamental flaw and weakness in our system of public administration, where the senior public servants are on fixed-term contracts and they're afraid. They're afraid to give that frank and fearless advice to the ministers. They had advice in the department, legal advice since 2014, that the scheme was unlawful. Yet there was a deliberate and orchestrated campaign over the next 5 years to maintain and continue and perpetuate the scheme. And this meant that they were leaving legal advice in draft form. They were misleading the ombudsman as well. They hid some legal advice from the ombudsman. They tried to manipulate the ombudsman's report, things like that. And the ministerial advisors put on a smear campaign as well for any Social Security recipient that dared to speak up. There was a media campaign trying to smear their reputation and say, this person is awful for these reasons. So there was a very deliberate and orchestrated campaign over 5 years to perpetuate a very damaging scheme. And that's what the Royal Commission report showed us, that the public service, the ministers, and the ministerial advisors were all complicit in continuing this scheme that has harmed hundreds and thousands of people.
While you have the microphone, Yufui, so the title of today's panel discussion is Administrative Justice After Robodebt. So I thought it'd be fitting to turn to that now. And I should have mentioned actually when I introduced you that you're working, I think, now on a comparative study of Robodebt and similar scandals and similar sort of problems that have arisen in other jurisdictions. So without asking too open-ended a question, would you mind telling us about how other jurisdictions have responded to similar problems and what those similar problems were?
Yeah, sure. So I was in the US last year on a Fulbright scholarship, and what I found out when I went there was all these scandals were also blowing up at the state level. So Social Security is administered at the state level in the US. So for instance, in Michigan, they had a governor who was trying to run the government as a business, same as a business. So what he did was he sacked all the unemployment agency staff and they put in a shiny automated system called MIDAS, the Michigan Integrated Data Automated System. And it cost $46 million. Turned out that the automated system had an error rate of 93%. So Robodebt was probably 30-something%, 93% of the debts were all completely wrong. And people were losing their houses. They were, losing their cars. They're not able to, they had to, go bankrupt and things like that. And this system was very punitive. It garnished their wages, so it automatically took their wages, quadruple penalty interest, so 400%. So people's credit ratings plummeted. They went into significant debt, and consequently, they lost their jobs. They couldn't rent houses. A couple of people attempted suicide as well. So very catastrophic. And it went to the Michigan Supreme Court, which ruled that this is unlawful. It's a breach of the constitutional due process requirements of the American Constitution, and people could then sue the government for damages. In the UK as well, there's been the universal credit scandal as well that affects a lot of people, tens of thousands of people, and again, suicides, mental health issues, and so forth. And there's also the post office scandal in the UK, where 736 postmasters, so people running post offices, were prosecuted for fraud. So there was this accounting system that said, oh, you've stolen this money from the system. And that resulted in all these people being prosecuted in the criminal courts. They were sent to jail, including a pregnant woman, a teenager. They were thrown in jail. Many of them faced bankruptcy and financial crisis, but turned out the accounting system was producing all these glitches. They hadn't done nothing wrong at all. So, so it's been decried as one of the biggest miscarriages of justice in the British history. So we've seen that these automated systems have been deployed at large scales to all these different populations, and some of them are very vulnerable. And so Robodebt is not an isolated incident. We see this happening in very developed, advanced democracies with all these checks and balances. So it is a worldwide global phenomenon that we do need to learn how to regulate.
And so I guess a related question, and I don't know if anyone else on the panel wants to jump in on this as well, is there anything about these other jurisdictions, legal or administrative arrangements that has meant that their response has been more or less desirable than our own?
Yes, so what we have in Australia is just administrative law, so plain vanilla administrative law. So the debts in Robodebts were ruled to be irrational and therefore unlawful. So that's attacking the outputs of the decisions. So we've got the outputs that you can say this automated system produces an irrational decision, it's unlawful. In the UK and the US, there are other bases that you can challenge the decision. So for instance, in the UK, you can challenge it through anti-discrimination principles. The inputs that go into the system are biased in some way. They overrepresenting Black people. They are saying that, or women, or so the inputs that go into the system are biased, and we can challenge that on the basis of anti-discrimination principles, and that's been done successfully in the UK. In Australia, we've got quite a weak system of anti-discrimination law, which disfavors indirect discrimination. So for this automated systems, the government doesn't intend to discriminate. It will have to be indirect. But the Australian law is quite weak on that aspect of things. In the UK, there's also very strong protections for privacy or data protection. So the use of AI data can be challenged in the UK under the European Convention of Human Rights. So human rights principles plays into the UK system, and constitutional principles play into the US system. As we know, Australia doesn't have very strong constitutional protection for rights. So it hasn't really been a plausible avenue for us here, but we can see other jurisdictions have broader avenues to challenge automated government decision-making than we do.
Did anyone else want to?
Yeah, I agree with those. The Dutch example, the childcare benefit example, was brought undone by the strong EU human rights basis. It's kind of akin to the US strength of its constitution. The states in Australia that have got a human rights act, it's as was just Yifui was saying, it's a very weak one. It's the so-called dialogue model. And even the model that the Australian Human Rights Commission is touting at the moment. On the 7th of April, I was on at another session on record as saying it would not have stopped Robodebt. And so unless you can convince the Australian polity, and I don't think you can, to introduce a really strong, that is to say that human rights always trumps the politics, then I'm afraid that the only avenues that we can consider to ensure this doesn't happen in the future are to strengthen the judicial review, administrative review, ombudsman, and those other mechanisms. People who are looking for salvation through a human rights initiative, I think, are not. Yeah, it's not a campaign that I would endorse.
I guess one question I had is there scope for, and this is going slightly off script, but is there scope for a more constrained welfare rights act, or so legislative protection of the rights of welfare recipients in this?
My view is that the politics in Australia, which are, I mean, the key theme of the report is how we take joy out of scapegoating the unemployed, the dole bludgers and so on, and that we're actually the best in the world at that. I mean, the scapegoating of the vulnerable accounts for the Dutch, the Midas, the universal credit, and all the other scandals. I mean, why the government pick on them? Because there's much more money to be recouped by putting AI into those systems, and you get away with it. There's not going to be any political pushback from constituencies representing them. Well, in Australia, our constituency in support for the poor and the vulnerable, I'm afraid, historically, pre-federation and since federation, has been, the weakest, the worst in the world. So I don't see any prospects of a Bill of Rights or a Welfare Rights Act. Think about the current legislation. It exempts the Act from the anti-discrimination and any other of those protections. Weak though those anti-discrimination laws are, these acts are exempt from it, and I don't see any prospect of changing that in Parliament.
There have been some moves in Australia to try to address some of the challenges of administrative law in relation to technology. New South Wales is one area that have developed that. Prior to the last election, the Australian Council of Social Services was successful in having ACOS, the then Labor opposition work with the crossbench, and were able to pass an amendment through the Workforce Australia, which is the Employment Services Network, the new online system, and it was called a Technology Protection Framework. And the Technology Protection Framework in the law required a regulation that said that decisions under this new system and the interface and reporting system needed to be consistent with human rights, and there needed to be non-discriminatory and transparent and accountable. Now, very few people know about that. One of the challenges is the technology, if it's used in profiling and other things, do not amount to an administrative decision. So the technology perfection framework do not deal with those things unless they actually are an administrative decision that is under law and that is appellable and reviewable. But technology is increasingly being used for making administrative or making organizational decisions that do not amount to a legal administrative decision. The other element is that the IT people do not seem to have a clear understanding of how you actually would implement these principles regardless. So there's a lot of work yet there to do. And I think that idea about the mismatch between technology being used in subterranean or non-administrative decision-making, something we'll come back to later.
Yeah. So while we're talking about administrative law and administrative decision-making, I wanted to talk briefly about the federal court's decision in Pinterick, with the Pinterick and Deputy Commissioner of Taxation, which was cited in the report. So Terry's mentioned the decision Bond, which is another decision that sort of places some limitations on the use of administrative law in these kinds of contexts. I'm myself not an administrative lawyer, so I'm right over my skis here, but Yifui's also co-written, I think, an article on Pinterick, which was cited by the Commissioner in her report. So I was wondering, Yifui, if you wouldn't mind, for those of us who aren't aware what Pinterick was about, explaining it briefly and then telling us what you think the proper response to that is.
Yeah, sure.
Yeah.
Yay, Admin Law 101. Okay, so there's two main avenues for challenging a decision, administrative decision in Australia by judicial review. The first is the Administrative Decisions Judicial Review Act, ADJR Act. The second one is Constitutional Judicial Review through Section 75(5) of the Constitution. And the case of Pinterick was about the first avenue, the judicial review under the ADJR Act. And under the ADJR Act, if you want to challenge a decision, it has to be a decision of an administrative character made under an enactment. And what the court in the majority in Pinterick said that a decision, the word decision, requires a process of deliberation. And the dissenting judgment said that, oh, if it requires a process of deliberation, that means automated decisions do not fall within the ambit of the ADJR Act and therefore cannot be reviewable. So Pinterick was about a tax decision where they it was an automated decision and they inputted the relevant details and it sent the debt notice to someone. So they said that's a decision that's not reviewable because it doesn't have a process of deliberation. However, this means that that there might not be judicial recourse or individual recourse or remedy for decisions under the ADJR Act if they are automated. And we know that the government is quite evangelical about, you know, the use of AI and automation in government. So this is a worrying trend. It's because the ADJR Act focuses on the process of decision making, that it requires a process of deliberation. Constitutional judicial review is where you can get a remedy where the decision is made by an officer of a commonwealth. So as long as you have a legislative deeming provision saying that a computer's decision is deemed to be the decision of the secretary or the minister, that should solve that problem. So there should be still that avenue of judicial review. But yeah, what we see in the other jurisdictions in the UK, the idea of judicial review hinges on the function being performed. So is this performance of a public function like running a prison? So it doesn't matter if a private body is running it, it's still subject to judicial review. Our courts haven't evolved in this way. They're still sort of stuck in this quite formalist view of what should be reviewed. And the UK types of decisions like data fin allow for more reviews of decisions carried out by private contractors, private bodies that are of a public function, decisions that are automated as well. It doesn't matter who made the decision, as long as it's a public function. If it's made by computer, you still can review it. In the US, they focus on the impact of the decision. So if the decision impacts someone's life, liberty, or property, and property is defined broadly as social security benefits are defined as property, then you can review that decision. So whether it's made by a human or computer, doesn't matter. So, so our courts, unfortunately, have been stuck in this quite formalist view of what is reviewable under the judicial review under the ADJR Act and the Constitution.
Can I just add on to this? The Commissioner Holmes made a significant comment in her report about this particular decision and the ambiguity about the lawfulness of automated decisions. For me, that decision of Pinterac also repeats an issue that was raised about 30 years ago in the department in Social Security, where a decision was found to be unappellable because it was made by a computer decision. And as a result, the government then issued into the DSS Act that a decision that the secretary could delegate to a human or a computer a decision under the Act. And you see now dozens of references to this in law, both at state and federal level, where computers are given the authority to make decisions. But this recent federal court decision questions that, but so does a decision in the New South Wales Ombudsman, where the Office of Revenue also automated the decisions of debts and taking of money from people's bank accounts, and it was found that a human had to put their focus to making that decision. So there's a lot of ambiguity there that's still causing a lot of ructions. A lot of people in my area think that the federal court made the wrong decision.
Yeah, I was going to ask if anyone wanted to venture whether they thought it was Pinterac
Well,
was
they
rightly
do.
decided.
So I don't concur in dissent, and the president of the Administrative Review Tribunal, AAT, I mean, understood how a decision should be framed. Well, Pinterac, it's going to require legislation to sweep it aside and introduce provisions that are an extension, really, of the section that Paul just mentioned. Yeah, because I mean it's perverse that we should be narrowing the opportunities to challenge automated decisions when they're as problematic as we know they are.
Our illustrious former dean was one of the majority judges in that decision. I'm not sure.
Probably.
Yeah. So while we're talking about the AAT, Terry, so it's my understanding it's been abolished. It's soon to be replaced by a new body.
Well, it'll be replaced, and yeah, until then, the AAT is still functioning.
Right. Yes. Yeah. We're not without an appeals tribunal. Do you think Robodebt has any particular implications for the future of that new tribunal, or are the problems that led to the replacement of the AAT much broader than Robodebt?
Oh, well, the problems that led to the replacement of the AAT were that it had been infected with partisan incompetent members, rather too many of them. The table at the back of the Royal Commission report that sets out of the 500 odd Robodebt matters that got to the first level of the AAT, the 210 that were decided like mine, and will enable you to see how other members dealt with equivalent issues. And the membership had got to the point where it was affecting the quality and efficiency, both quality and efficiency of the work of the tribunal. The recommendations of the Royal Commission in 19.2, 19.4, 20.2 and etc. would ensure that none of that Robodebt would have been stopped in its tracks. I mean, for example, one of the recommendations is that there be a process whereby the AAT in its first tier level, which handles between 10 and 14,000 cases a year, and despite that, it's still only 5 out of every 10,000 Robodebts that got there, which shows how important it is that you keep that mass decision-making level, would be in a position to be able to de-identify and publish key rulings, you know, like the ones that I gave or that other members were giving. Had that become public, it would, the gaming that went on, because there were public servants who actually committed to writing, as documented in the Royal Commission, who said, we're not appealing this case, not because you know, of any other reason, but that it would render public the doubt about the legality of Robodebt, and that would be inimical to the continuance of the scheme. I mean, that dereliction of public service and other ethical responsibilities, I mean, that we'll talk about later, is part and parcel. There's also recommendations designed to ensure that public servants, lawyers and others never are put in that position where they so, you know, abnegate their responsibilities that they do the bidding, even when it's unlawful or unethical, of what they see to be the secretary or the government of the day. But the short answer is, I think there's an absolutely excellent, very practical, easily implemented set of recommendations that will fix the AAT as it has been. That said, I am, and I have made public, I have had concerns about the issues paper and the meeting soon after the issues paper that the team had developing the new AAT with me, because I think they don't understand the need to ensure that for the mass decision-making, you know, they're talking about having uniformity. They're talking about having legal representation for everybody. They're talking about all decisions being made public. They're talking about the department somehow putting a fuller statement of its reasons for the case than the one that's in the authorised review officer decision. And, you know, frankly, they've got as little grasp of the character of mass decision-making for the ordinary person in administrative review as those two judges, whoever they were, in Pentarec, okay? And I'm worried that the sort of fresh out of law school type, you know, looking for uniformity and things that look good on paper, may lead to us seeing later this year an AAT design, replacement design, that takes us backwards from where the AAT was, because the problem with the AAT was only those two things: some members who weren't up to it, and the fact that it was able to be gamed by the decisions never being appealed, and so on, and the tribunal not being in a position to be able to make public when those decisions weren't being taken further.
If we did.
Yeah, so very good points by Terry. I was part of that consultation process as well of the new AAT, whatever it is, ABT, AIT, whatever, AA something, AGT. Anyway, so the new body, they are thinking of quite wide-ranging reforms. I thought it was all about the appointments process and, you know, it being politicized, 30% directly partisan appointments, but they are looking at quite a whole-scale review of the whole structure. And I think they are quite cognizant of the Robodebt issues that, okay, we're dealing with individual adjudicators here making lots and lots of decisions. But how do we identify the systemic issues that have come up, as Terry has identified in his individual decision-making capacity? How do we get that noticed at a broader level? And I think one of the suggestions was to reinvigorate the ARC, the administrative review body that was overseeing administrative law at the broader level. Another option is to have a first tier and upper tier tribunal like in the UK system, where like more serious questions can be referred to the upper tier of the tribunal. Another one is, like Terry said, the START cases. So they do this in the UK. They start important cases, and that's published on a centralized website. It's very accessible, and it indicates what matters are quite important. So I think those kind of reforms would be very good. I put that in my wish list, but who knows what they'll come up with. We'll have to see later in the year.
Great. So I am conscious of time, and there are some other issues I want to talk about. So I had a question about, what further steps could be taken to ensure proper oversight, but I think I might ask that at the end. Instead, I'd like to move on to the implications of the Robodebt report, in particular for the public service and for legal profession, both as on its own and as a sort of profession that contributes to public service. So I'll sort of ask I'll try to simplify the questions I wanted to ask. The first is, I think Robodebt is already going to be used. It already is used as a case study in legal professional ethics courses. I know that because I spoke to our coordinator earlier in the week. What does it tell us about the ethics of the legal profession and how it might need to be reoriented? And so I'll ask the two questions together so we can all talk. And the second is, when it comes to legal professionals working within the public service, what are their particular responsibilities that it appears they've been neglecting? And is there something we can do to address that, or is it just a cultural issue that needs, and cultural issues are the hardest to address?
I'm sure you Fui and Paul will have some views. Again, the Commission has some really excellent proposals. Referring to the Administrative Review Council that everybody says should be re-established, it's going to give it, if it's implemented, a training function for all lawyers in the Commonwealth Public Service as to their ethical responsibilities to give, independent advice in accordance with the professional ethical obligations and the obligation of the model litigant, which is a common law principle that's just been codified, that is all about the enormous power of government on the one hand and the extreme vulnerability of all citizens on the other, and ensuring that government doesn't abuse its power by failing to try to equalise and put before. I mean, there was criticism that, for example, that none of those Robodebt decisions were ever circulated to other AAT members or passed up through the policy-making arms of government and so on. So there's a set of measures for internal training by the departments, by the external administrative review tribunal and so on, and including training. I mean, and it's a reflection on law schools, isn't it? That when you give an opinion, that you ought to cite some legislation and some cases. I mean, that is explicitly built in, the integrity stuff and the giving a proper legal opinion as the things that people need to be brought up to speed on. I would add to that, I mean, I don't know what we're going to do about the fact that there are only 3 or 4 people in the whole of Australia who understood what because nobody gets any social security even as an option anymore in law school. It's as large or larger and more complicated than the Tax Act. So it's just think what the public would be like if we didn't ever teach anybody any tax in Australia, any lawyers any tax. So nobody knows the law outside a few people, who bring themselves up to speed from time to time in the welfare rights and other legal aid commissions. Why were the test cases a Victorian test case? Because there were only one legal aid commission in the country, the Victorian one, actually did any social security work. So it's broader than just the legal ethics. It's broader than just the lawyers, because that imbalance between the power of government and the vulnerability of citizens, it's an obligation across every public servant. That includes the lawyers who are legally admitted, the lawyers who are not legally admitted and are doing other work, and all the non-lawyers. I mean, it's that common law responsibility of the model litigant and the model, if you like, responsible public service, reaching appropriate ethical standards of good administration applies to everybody. So that outside those chapters, that's why the people who Paul will speak about, I'm sure, and Yifui, all of that work within the public service to give effect to the Thody report, for example, the external review of the public service. It made a lot of critical and constructive recommendations about ensuring that the public service was, re-enabled to do the job that it used to do a few decades ago, before all of the outsourcing and other things that have diminished the capacity and the number of staff and the quality of staff and so on. So there's a whole set in chapter 19, I think it is, and Paul, and numbers of other reports that they commissioned, expert reports, on the steps that need to be taken to shift that whole public service culture.
I just want to say briefly, as a non-lawyer, and I don't want to engage specifically with the legal profession in the public service, but I think they are also part of the culture of the Australian public service. And Professor Andrew Podger, a former Australian Public Service Commissioner and a former Secretary of a federal department, was asked to write a report for the Robodebt Royal Commission, and he made the point that the public service over the decades since the senior executive service have been contracted have become over responsive. That was the term he used. And I think the lawyers, both the ones that are appointed as lawyers, but those also inside, are captured within that. That said, there are many people within the public service in DSS and Service Australia who were dismayed by the way in which the Robodebt Royal Commission did. But the key thing is, it's just the people who get promoted up to those levels operate in a certain way that gives them rewarded in certain ways. And there are obviously already in the APS values, things like acting lawfully, acting in the public interest. But when you have been told that the minister is your number one customer, you do what the minister says or what you even think the minister wants. And that's why it's possible for Secretary Campbell to do something and not tell Minister Morrison, because she knows, wink, wink, nod, nod, this is how it's going to happen. And so the other aspect in terms of lawyers is recognising that the way in which you operate in the public service is different to the private sector. You are working for the public, you are working for the most vulnerable people. If you're lawyer shopping to get a certain response, you've got to say, what's the implications of that to the citizenship? And what are the accountabilities to that? And it goes back to those things as a culture, as well as the professional responsibilities.
I agree. Basically, as a escaped government lawyer, I did see a lot of practices within government that were questionable, as in trying to evade accountability, trying to hide things that made the government look bad. And this is part of a broader cultural phenomenon in the public service. And I think it goes to what Paul says, the people who do get rewarded and promoted in that system are the people who know how to play the game. And part of the game, as we saw in this whole Robodebt situation, was playing along with what the minister wanted. The minister wanted to punish all these, what he called, he was the welfare cop, punishing the dough bludgers, that kind of thing. And the lack of questioning of what they're doing in their day-to-day work and how that aligns with the values that they are supposed to uphold. I think some of that does get lost. And I think the public service has been weakened over the last 30 to 40 years with the rise of ministerial advisors. I've been writing about this for a long time, and the lack of accountability of that group as well, who also have been implicated in the Robodebt scandal. So our legal system has not kept up with the evolution of our public administration. And that has resulted in all these very large scale scandals because we have not yet held to account. I guess the Robodebt Royal Commission is one way to expose all these issues and show that there is a lot of weakness in the way our government functions today. And yeah, how do we fix this situation, which is institutional, cultural, and also the interactions of power between all these different ministers, ministerial advisors, public servants is dysfunctional now. How do we fix that? And how do we ensure accountability?
Yeah, to editorialize very briefly for my part, if you're a lawyer or a law student who hasn't read the report and don't plan to read the report, you should still read the chapter that deals with the legal profession, because I found it completely shocking as someone who's not personally familiar with the public service, the way that these legal professionals conceived of their role and interpreted it. I wouldn't have thought it was coherent to interpret your role in that way. But clearly there's, as Yifui said, a long-standing practice of engaging in this kind of conduct that has led it to it being normalized.
Also, those who spoke up were punished. Their careers suffered, and yeah, they were sidelined or dismissed. So they face personal reprisal for speaking up. So yeah, it's a broader cultural phenomenon.
So I think we should finish very soon and give people a chance to ask questions. But I did just briefly want to ask Paul about the concept of vulnerability, because I know, Paul, you've got a long experience in social security, and it's mentioned in the report. But what is vulnerability and why is it so important in social security? And then also, how can we make sure that vulnerability indicators are factored into automated decision making?
Thanks, Rob. Well, I guess the first thing to notice, and Yufui's summary of international examples highlights the ways in which governments have used automation and in a sense, new systems that for the most vulnerable parts of the population, which of course is going to have big consequences, big personal consequences when it goes wrong. And that should be an area of concern to ensure that systems are designed appropriately for when we're using it with the vulnerable, to see, well, what's the downside risk? As Terry said, we've got a culture where we don't care because they're the ones that we scapegoat. But Centrelink has a vulnerability indicator, and I don't know enough about how that's determined. And obviously, things like mental health is a key component of it. People experiencing domestic and family violence would be an indicator of that. With an automated system, you have the capacity to, when you have that kind of indicator, to do things differently for different groups of people. And in fact, with AI, you can start to be a bit more sophisticated in identifying who might be vulnerable and operating differently. And I think we need to start to think, how do we operate differently for people's levels of vulnerability? So do we create services that are automated for 96% of the population, but for the 4% that are vulnerable, do we make it more of a human service centre? Another key important aspect of vulnerability in the system is actually making sure that we co-design systems that take into account the lived experience of people. The Workforce Australia app that was developed, it was apparently assessed to be suitable for unemployed people. When asked who did they assess it with, they said two people in the department. So two IT people who are actually well-educated, living in Canberra, are not exactly good examples of unemployed people, who often had old version model mobile phones, did not have enough data to actually access. They couldn't even upload the app, or even if they did, they couldn't use the app. So we do need a greater understanding of the lived experience of people when we're designing systems, computer systems and automation for that group. But that's the answer to your question.
That's a wonderful answer. I think a good note to end on. We have some time for questions. I'm conscious that it's during semester, people are teaching and learning. So if people need to leave, they shouldn't worry about leaving the room. I thought we'd start with an opportunity to ask any questions from the floor. And then I'll take questions. If you're following online and you have a question you want to ask, you can use the chat function to ask a question. I'll look at those shortly. We'll start from the floor if there's anyone in the room who wants to ask a question. Yes.
How likely is it that the stigma has like
You may need the microphone because the people online won't be able to hear.
Thank you.
That's my fault.
thanks. How likely is it, because stigma has quite a significant portion in the report itself, how likely is it that the concept of stigma and the preconceived ideas that people in the public service that carried out this Robodebt scheme, how likely is it that stigma was weaponized within the public service in order to encourage complicity from the public service that carried out this sort of scheme? Yeah.
I think stigma is very much part of the culture of how we deal with people who are poor and reliant on social security. That we've always had this undeserving attitude unless you're an age pensioner or receiving family tax benefit or something like that, which allows that kind of brutalized treatment of people living in poverty. Stigma also is problematic because it also means that people in those positions often do not take up the opportunities of their legal rights. So there is plenty of stories of people just paying the debt because they don't understand it. Two, they feel embarrassed by it. They think it's their fault, even if it's an administrative error or even not an error at all, but not their fault. It's a wrong debt, for example. So there's stigma stops people from accessing. There's stigma also stops people from actually accessing social security when they should be actually able to access it. So it is a significant ongoing problem for the operation of those systems. And public servants, look, I know a number of people, and I know a number of people who've used the system, and there are a lot of positive experiences with people in Services Australia, but there's also negative experiences that you can see popping up on Facebook and social media posts about how they've been treated poorly by staff. But I think it's just a mix of the population, really.
Hi. Hi, thanks for organising this talk. You would have seen that Four Corners episode in a week talking about the revolving door between the public service and the big four consultancies. I'm not aware of it, but were any external consultants brought in to advise on this Robodebt scheme, or the early precursors? The reason being that involving technology and data matching, given that government departments aren't very good at sort of linking up data. There's all these data silos across departments. And also, was any sort of commentary on even just the term Robodebt? I've heard other people say that doesn't really sort of reflect the gravity of the outcomes of the scheme. I mean, you could call it Robodebt, but then probably the robotics industry wouldn't like it to be called that, because robotics can be used in positive ways. Yes, I was wondering if you could comment on those two questions.
I guess just the first thing I should say is that Robodebt in different disguises is still happening. I'm working with Economic Justice Australia, which is the peak body representing welfare rights legal organisations, and they're doing a research at the moment. Terry's also helping to support, trying to understand where automation is causing problems for welfare rights lawyers and for social security recipients. One example is that of automation problems is that people in Australia receiving special benefit are people who are not permanent residents or citizens can receive special benefit under certain visa categories. In the Migration Act, as your visa starts to come to expire, you can apply for an extension or you can apply for a new visa. Under Home Affairs, that if you've got an application for a new visa, you continue on the current visa until that decision has been made about a new visa. The Home Affairs system says that shows that your visa is expired as of a particular date. That is then data matched with Social Security. And for Social Security purposes says, oh, your visa has expired. We cut you off, so special benefit. Now, this may only affect tens of thousands of people, but these are the most vulnerable tens of thousands of people in Australia. Each department says, not our problem. I'll give you another example. This is from a former colleague of UQ. It's not a poor person who was working as an academic and now in the public service. She recently got a $10,000 debt notice because of saying that she was not eligible for childcare benefit because she didn't meet the work test, which means you can't receive certain amounts of childcare benefit or childcare subsidy unless you're actively looking for work or in work. This person was working full-time the whole time. Somewhere along the line, her information that had provided had slipped off. But rather than checking to see whether that was correct before raising a $10,000+ debt, it automated. And that's happening all the time. So we've got these problems and we actually are just assuming the computer is correct, which is the case which is the disaster in the UK Post Office Postmaster's case. So automation is useful, but we need to be alert to the errors. I won't tell this example, but 4 or 5 years ago, I was interviewing someone in the office of the Canadian Chief Information Officer, our office, and they were telling me about their vision of having data flows go throughout state, federal and local governments. And they gave the classic example of a child being born, would be registered, it would flow through to the local health system, that would flow through the local school system, it flowed through the federal childcare benefit. And I said, that's great. But can't you imagine if you have an automated flow through system where someone says that this child has been abused or neglected, and for whatever reason, it was either erroneous because the name was given was wrong or was investigated and found to be inaccurate. How do you undo the flow-on consequences of sending this information to the juvenile justice system, to the child social work system, to the school system? The response was, oh, I hadn't thought of that. It says everything about computer scientists and also lawyers, the idea that this model world will, if we only got the code right, or only got the law right, things will work perfectly. The reality is that the world is messy and we can't design it for those. We need to be alert to that messiness rather than what is intellectually pure and perfect.
So 3 questions. We might take a few of them at once, maybe, and then just let the panel respond.
Thanks, everyone. I was wondering whether there's anything we can learn from the things that might work with things like external dispute resolution systems where the government set up or organized for things like utilities. So being able to complain about automated decisions about your credit rating and so on, or the telecommunication industry ombudsman. I mean, the sort of things, because this isn't just about administrative justice, it seems to me. This is a much wider question about mass decision-making and automation and the kinds of, at least the sort of things that are now we would consider to almost be human rights or utilities, such as access to finance and telecommunications. And maybe it's a question for Terry, I guess, because you seem to be saying a lot of this could have been headed off if the AAT had been not gamed and had better capacity, and yet you also were saying that it's naive to think that you can have a mass AAT and be run the way that first-year law students might imagine a body.
The short point, it's an easy fix. It's an easy fix. There was just one ingredient there that was missing, and that was the power to publish those key decisions, and then a willingness on the part of the leadership of the tribunal to ensure they have an internal process that draws it to attention. These decisions of mine were made public to every AAT member from New South Wales and Queensland who attended the training session in May of 2017. And so if the power had been there, I've got no doubt an anonymised decision would have been published. I'd already made public to those members that I had anonymised 2 of my decisions. So they were ready, they would have been capable of being posted, you know, straight away. And government could not have got away with continuing. They might have continued it for another 4 or 5 months, but it could not have gone on until for as long as happened. And the numbers were building all the time. I mean, they were almost exponential, the number, the growth of numbers.
Rule of law, if you like. Right, but I thought you were implying that the idea that you could have legal representation and publishing of the identified decisions across the whole of the might be problematic.
Oh, I'm sorry. The problematic part is people who think that all law is done in courts. And a lot of lawyers trained and believe that. And so, whereas in administrative tribunals for the mass decision making, it's an inquisitorial process. You as the member have to try to work out what it is that is the basis of the concerns that are remediable by the applicant, what the department's position might be, because it won't have articulated it, and then as the decision maker, what the correct and preferable decision should be. And, you know, good administrative lawyers the world around are familiar with the skill set of that inquisitorial process. So, yeah, and that's all I'm worried is that some of that may go out the door. I was consulted very early. He felt he might have been a bit further down the track. So hopefully the new replacement AAT will be as good or better than the old one.
Can we hear from these 2 questions and then we might answer and wrap up? Yeah. No, you're.
Really briefly, I wanted to say that there are social security practitioners at the Queensland Legal Aid Commission, but there's only 2 of us. And I wanted to ask if you've got any thoughts about what might come through in time in this space in relation to one-touch payroll, because I'm sort of waiting for that to go wrong too.
One-touch payroll was the solution that when the Senate people and I were giving evidence said, well, what should we do about it? Because they were very, including some Queensland senators, you know, who didn't like being told that there was a problem. I said, bring in the one-touch payroll, which is matching in close to real time, roughly the same days of payment to those of the employment income as reported. They're never going to be perfect because under the Social Security rules, the date, the fortnight for your payment purpose, you know, dates from when your application is accepted, etc. And there are some concerns in the welfare rights sector, we know, Paul and I, from the field work that's being done as part of the project we're both involved in, that suggest there are small, but nevertheless significant mismatches between what the person as a Social Security recipient gets is a screen where you're told, well, this is what the employer says, is this right? You click on that thinking, oh, yeah, well, that's, but if that's several dollars out or, you know, cents out and it accumulates fortnight by fortnight, people may find that they're locked out of review rights because, you know, it looked close enough. And nobody outside Social Security people, you know, knows how to do the correct calculation to know even then, and it would be time consuming and probably we wouldn't do it either. So yes, there may be issues to iron out in the future, and I don't know how they'll be ironed out. Maybe there should be a presumptive waiver of those, because the benefits to everybody of because one-touch reporting is well received by the sector, it seems. And so we don't want to cruel a system that's working well by, you know, yeah.
And it's cer-
allowing debts to accumulate.
and it's certainly going to reduce a lot of some of the debts that have already had it.
Yes.
That are likely to have had in the past.
My name's Sam Tracy. I'm Director at Basic Rights Queensland. We're one of the community legal centres that are part of Economic Justice Australia. My question comes from looking at the human element of administrative justice after Robodebt. And it's from reflecting on a few years ago when there was consultants engaged within the Administrative Appeals Tribunal to essentially dissuade people from continuing appeals. It was a contentious period for all of our advisors who would find out often after this person had attempted to dissuade the continuation of the appeal. And I'm just wondering, with the future of the AAT, with the changes, how can we or can we imagine that this kind of thing from a human perspective won't happen, that seems to hinder our vulnerable clients' prospects?
Well, the short answer is to ensure that an efficiency dividend is never applied to an agency like the AAT, because I was public within the AAT about the pressures of a declining budget and a static caseload, that it was leading to a lot of giving of oral decisions and less accountable, lower quality. I mean, in my 40 years, a lot of times I thought somebody had lost or won after I went out of a hearing. And if I'd given oral reasons, then I would have, made that bad decision. When I came to write it up, it tipped around because of the discipline of being required to produce written reasons. And so, those pressures were there in the last several years of the AAT, all because of the efficiency dividend that just keeps reducing the work, the money, and therefore the staff are able to process the caseload.
Did either of you have anything you wanted to say to any of the questions?
I've got a wish list for reform. So I think that judicial review is a measure of last resort. By the time you get to the courts, like hundreds of thousands of people have been harmed, as in Robodebt. So for me, there needs to be internal agency and government department mechanisms when you're procuring and designing and implementing the technology. So the government departments need to go through an impact assessment process that thinks about the potential harms that the technology might cause. So within government, there need to be processes to managerial controls to ensure that automated decision-making systems are deployed more responsibly than they have. The Robodebt has been pushed through without that necessary deliberation, and maybe because of political reasons, but to have processes within each government agency that requires them to publicly go through this risk assessment process that identifies the harm to potential harm to vulnerable populations. I think it's very important. And the political mechanisms of control are important as well. Graham adverted to that in terms of the Ombudsman, Auditor General, Information Commissioners. They have a role to play in scrutinizing automated government decision-making. We didn't see this work so well in the Robodebt situation. The Ombudsman was not given full information by the public service. The Information Commissioner decided not to investigate in an own motion investigation and didn't activate their coercive powers. But we can see that those mechanisms could have helped a lot more if they weren't subverted to some extent by the public service. And so, I think a complete solution needs to take into account legal, political, and managerial controls to stop harms like this from happening in the future.
Since you've raised the question about changes, I think, but there are a couple of things that from someone who's been looking at the way in which technology is being used in government and what Robodebt shows, there's a couple of things. First of all, our administrative process, the justice process, focuses on individual decisions. When you automate the decisions, you are creating a structural decision-making process. And if that structural decision-making process is erroneous, you're creating structural errors. We actually currently don't have any legal mechanisms, and it really was the class action as a way in which to challenge the algorithm as opposed to individual decisions. So we actually need to have legal process review, legal innovations to consider that. The second thing I mentioned before is about there are those uses of technologies that are being made, that are being used in government that actually don't directly contribute to administrative decision, and so are not actually appealable or viewable. And this is where we actually need to start thinking about making more visible about how automation is used to see whether it's reasonable as well as lawful. And in the Commissioner's report, a suggestion for an advisory, an automated decision-making advisory or an oversight committee to advise on these multidisciplinary elements is considered. There have been a number of things about like extending FOI into realms of being able to access the code or even the algorithmic design, and commercial and confidence becomes a challenge in that. The idea of a registry for AI is being used in places. There is also a growing area of audits, particularly in artificial intelligence, to see whether AI tools are biased or reproducing biased decisions, etc. And New York City actually has an AI bias law that requires audits of their AI to be assessed, to be done, and to be reported. So there is a whole lot of areas there that we need to think about. How do we give greater visibility and accountability to ensure that there is independent checks of the veracity and the appropriateness of automation?
And the recommendation 17.1 and 2 and 11.4 have, from the Commissioner, recommend all of those things, or virtually all of those things. Yeah.
Okay. That's a great note on which to end. I would just, there is a comment in the chat online, which goes to some of the stories that Paul has been sharing. It felt wrong not to share it, which is the viewer said, I'm a carer and I have to deal with Centrelink. It's a nightmare. From my experience, their behavior is vicious, especially when you start to assert your legal rights. And the user expresses concern that what happened in Robodebt is still happening, which I think goes to your point, Paul. And so perhaps on that depressing note, let's thank the panel for assisting us today and for having so many different, interesting and enlightening things to say. We have some tea and coffee for people who have time to stay around. But otherwise, thank you all. And I'd like to thank Caitlin and Rebecca, both who are here in the room, for their help in preparing the event.